a new line in the sand. For over a century, gun laws in America have followed one pattern: chip away slowly, hide behind regulation, and hope the people don't push back. But today, that pattern just shattered. A 9-0 Supreme Court ruling, yes, unanimous, has delivered a massive blow not just to anti-gun laws, but to the very foundation of how government powers are used. And this wasn't just about the Second Amendment. This decision struck deep into the constitutional fight over how far the government can go, how tax laws can be weaponized, and whether freedom itself has a limit when the paperwork changes. This changes everything. Welcome to Survival Firearms, where we don't chase hype, we break it down. If you believe in liberty, law, and the power of real information, hit that subscribe button now. This video might just be the most important one we've ever made. Chapter 1. The 9-0 ruling that shocked America. It's rare for the Supreme Court to agree 9-0 on anything these days, especially on a case with Second Amendment and tax implications. But that's exactly what happened in Barnes versus Felix, where the court unanimously ruled that a law based on a tax cannot remain in force once that tax is zeroed out. This wasn't a gun-specific case on the surface, but the implications hit the firearms world like a lightning strike. Key points. The Barnes case involved a Fourth Amendment question. Can police use excessive force if the law backing their action no longer has legal weight? The court ruled, if a law's authority was based on a tax and that tax no longer exists, the law has no legal standing. Justices across the political spectrum agreed, from conservative to liberal, in a rare show of unity. The logic behind the ruling connects directly to the National Firearms Act, NFA, and its $200 tax stamp. That tax, unadjusted since 1934, is now functionally obsolete, calling the foundation of the NFA into question. This wasn't just a courtroom decision, it was a judicial earthquake, and the tremors are now shaking the legal ground beneath almost every major gun control law in the country. Chapter 2. The collapse of a tax-based law. The government's argument in Barnes was simple. Even if the tax is gone, we can still enforce the law behind it. But the court wasn't buying it. They ruled that when a law's justification disappears, so must the legal authority that depends on it. That logic has enormous consequences, especially for the NFA. Key points. The NFA was built around a $200 tax, a price so high in 1934, it nearly banned ownership through cost alone. Courts previously accepted this tax as a way to regulate, not ban, certain weapons, like SBRs, suppressors, and machine guns. But if the tax has lost its value and the BATFE admits it's often waived or delayed, then the legal justification no longer applies. That opens the door to new lawsuits challenging the constitutionality of the entire NFA. The Supreme Court has now set a precedent. Laws propped up by outdated taxes are ripe for challenge, and could be struck down. This case may have started with one man's excessive force claim, but it ended with a legal doctrine that may dismantle entire gun control frameworks built on crumbling tax codes. Chapter 3. Firearms laws caught in the crossfire. The ATF has long relied on the NFA's tax logic to justify its most controversial actions, regulating suppressors, short-barreled rifles, and even stabilizing braces. But now that the Supreme Court has made tax-based enforcement vulnerable, these laws face an existential threat. Key points. The pistol brace rule, which reclassifies millions of firearms under NFA rules, may collapse under Barnes versus Felix logic. Forced reset triggers, binary triggers, and bump stocks, all targeted by redefinitions, now rest on shaky legal ground. Any enforcement tied to a tax or the appearance of a tax must now be re-evaluated under strict scrutiny. If the tax can't support the law, then neither can the enforcement, especially if no due process or legislative backing exists. Ongoing lawsuits in Texas, Florida, and Arizona are already citing the Barnes decision in Second Amendment defense arguments. Gun owners now have a powerful new weapon, not a rifle or a pistol, but a unanimous legal precedent that cuts straight through bureaucratic overreach. Chapter 4. The Bruen effect takes hold. The 2022 Bruen decision established that all modern gun laws must match historical tradition. Now, combined with Barnes, it creates a 1-2 punch. Not only must laws have historical precedent, but they must also be constitutionally grounded, not propped up by expired taxes or executive fiat. Key points. Bruen made it clear, the government must show historical analogs for any gun law, especially from the founding era. Barnes now says, If the original basis of the law, like taxation, is gone, the law must go too. Together, these rulings challenge not just one regulation, but the entire modern gun law regime. Anti-gun states can no longer rely on tax tricks, broad interpretations, or public safety arguments alone. These cases are now being cited side by side in lawsuits, amplifying each other's impact. For the first time in a generation, constitutional rights are gaining momentum in court, and the government is scrambling to defend rules that no longer have any footing. Chapter 5. The dominoes begin to fall. What happens when one legal pillar collapses? Others start to shake, and that's exactly what's happening now. Since the Barnes ruling, Pro 2A lawsuits across the country have been reopened, fast-tracked, or expanded because suddenly there's new ammo in the legal arsenal. Key points. Suppressor bans in states like Illinois and California are now facing new constitutional scrutiny. Legal teams are citing Barnes plus Bruen to argue that taxes and regulations on common accessories cannot stand. State-level laws that mirror NFA language, such as dangerous features bans, are being re-examined. Courts in conservative circuits, like the 5th and 11th, are more willing to grant injunctions. Even moderate courts are now asking tougher questions, no longer deferring to public safety talking points. With every court date, the foundation of America's oldest gun control law is getting weaker, and if one judge drops the hammer, the whole structure may come down. Chapter 6. NFA On the Edge. The National Firearms Act has stood since 1934, but now its foundation is cracking. The $200 tax stamp, once an effective barrier, now serves as the legal backbone for multiple restrictions. But Barnes versus Felix just tore through that foundation. And now legal experts are asking the unthinkable. Is the NFA legally dead weight? Key points. The tax stamp model may be invalid if the tax has lost economic meaning, as established by Barnes. Challenges to suppressor regulations, SBRs and AOWS, any other weapons, are now surfacing in courts nationwide. Legal scholars argue the NFA may lack a valid constitutional justification post-Barnes. The ruling opens the door to questioning the registration requirements tied to the NFA. Second Amendment groups are already preparing multi-state coordinated challenges using Barnes as a weapon. What was once seen as an unbreakable law is now becoming legally unstable, and the nation may witness the biggest transformation in federal gun regulation in nearly a century. Chapter 7. California Model Crumbling. California has long served as the blueprint for restrictive gun policy. Rationing, waiting periods, accessory bans, key, but now that model is unraveling. The Barnes ruling combined with Bruen means courts are no longer rubber-stamping state-level laws. Key points. California's one gun per 30 days law is now under federal challenge. Other states, like New Jersey and Virginia, that copied California's model are seeing lawsuits filed immediately. The courts are beginning to recognize that public safety can't override constitutional precedent. Accessory bans, flashlights, red dots, lasers, may soon fail strict scrutiny tests. Judges are citing Barnes in cases where California's laws previously went unchallenged. Once the gold standard of state gun laws, California's model now finds itself on trial in courtrooms across America, and the tide is turning fast. Chapter 8. States hit the panic button. As news of the 9-0 decision spread, governors, attorneys general, and legislators in several states began re-evaluating their own laws. The Barnes ruling didn't just spark courtroom action, it ignited a political scramble to get ahead of the legal fallout. Key points. States like New York, Oregon, and Illinois are reviewing pending legislation that may not pass constitutional review. Executive orders related to firearms enforcement are being paused in some states. Attorneys general are issuing internal memos warning about the increased vulnerability of tax-based laws. Some states are preemptively repealing or amending gun laws to avoid lawsuits. State-level gun rights groups are launching new campaigns and ballot initiatives in response. In just weeks, a ruling that most Americans didn't even hear about has already changed the behavior of state governments, proof that the Supreme Court's decision was anything but symbolic. Chapter 9. The new blueprint for 2A cases. For decades, Second Amendment litigation felt like a losing battle, but now attorneys have a clear playbook. Cite Bruen for a historical mismatch, and use Barnes to dismantle tax-based laws. This 1-2 combo is shaping the next era of 2A defense. Key points. Barnes gives gun rights attorneys a tactical edge in challenging outdated federal laws. The decision adds momentum to pending appeals on stabilizing braces and forced reset triggers. Combined with Bruen, Barnes sets up a judicial path for full NFA reform or repeal. Legal foundations like FPC, GOA, and SAF are coordinating across multiple states to file synchronized challenges. The courts now have a clear precedent to review gun laws through a lens of history, original intent, and constitutional consistency. This isn't just a legal moment, it's a constitutional shift. For the first time in modern legal history, the tools to dismantle overreaching firearms laws are not only available, they're winning. Chapter 10. What's next for gun owners? The fight is far from over. Lawsuits take time and governments rarely give up power without a struggle. But for American gun owners, this moment is historic. The Supreme Court has affirmed limits on federal reach and validated constitutional scrutiny in a way we haven't seen in years. Key points. Expect more court victories in the months ahead, including possible rulings against the pistol brace rule and more. Gun owners should track legal developments closely, especially in their state legislatures. Carry permit laws, accessory bans, and registration schemes are now open targets for review. Education is power. Knowing how Barnes and Bruen work helps ensure your rights aren't quietly eroded. 2025 and 2026 may become the most important years for 2A restoration since Heller and Bruen. This isn't just about winning a case, it's about restoring balance to the law, honoring the Constitution, and protecting the tools that safeguard freedom. Survival Firearms is just getting started. If you've made it this far, you're not just watching the news, you're becoming part of a movement. One decision from the Supreme Court can change the legal landscape for decades, but it takes informed, empowered citizens to carry that momentum forward. At Survival Firearms, we're not just breaking down cases. We're making sure you're always 10 steps ahead of the next big legal shift. So, if you believe in freedom, firearms, and facts over fear, hit that subscribe button and join the front lines of truth. Drop a comment below. Do you think Barnes versus Felix just opened the door to NFA repeal? Or is this just the first battle in a longer war? This isn't the end, it's just the beginning. And we'll be right here with you every step of the way.